I believe the time period now is 21 days from arraignment. He intends to waive that that statutory right and to have the preliminary examination scheduled out. That really is for purposes of allowing me an opportunity to fully understand the state's case.
All right. Have you received discovery?
I received discovery. I received a copy of the complaint and what looks like 2 DVDs or CDs, and then there's 1 thumb drive. I can't begin to tell you what's on it, but I would assume that given what I believe to be the case, that we'll be more than ready to proceed by January 13th.
All right. Is there any additional discovery?
There's some medical records and a couple of supplements that I received this morning that I need to make copies of, and I will get those to Mr. Rockand as soon as I get back to the office.
All right. Let me talk to Mr. Warren. Mr. Warren, can I have you please raise your right hand? You solemnly swear or affirm the testimony that you're going to give this court is the whole truth?
Yes.
All right, thank you. Mr. Warren, you've heard the representations made by your attorney as well as the prosecutor in regard to this matter or the preliminary examination. Is that correct?
Yes.
You understand you have certain statutory rights. One of those statutory rights is to have a preliminary examination within a certain amount of time from your arraignment. In this particular case, it's within 21 days. Do you understand that?
Yes.
Based upon the representations of your counsel, it's my understanding you're asking the court to waive that right due to the fact that you and your attorney have to elect the opportunity to review the discovery.
Yes.
Is that correct?
Yes.
Are you waiving that right voluntarily?
Yes.
All right. The court finds a waiver to be knowing and voluntary. The court will waive the statutory period of time. We will set this preliminary examination, and it's my understanding the parties have had an opportunity to consult their calendars as well as the court's docket, and a date of January 13th of 2016 is appropriate for both parties?
Yes.
Yes, Your Honor.
Judge, could I address a couple of the bond issues that that came up between Your Honor, Mr. Hudson, and myself? Okay.
So we'll set preliminary examination for January 13th, 2016 at 8:30 a.m.
Thank you.
All right. Now, in regard to bond, the court has received notice from pretrial services. Mr. Warren has been placed under pretrial services pursuant to the bond requirements in the bond hearing that was originally held at his arraignment, and I've received notice of a number of violations. Are both parties aware of those violations?
Yes, Your Honor.
I'm aware of them now, yes. I'm prepared to answer them. It was my intention to actually come into court today to move to actually modify some of the conditions of Mr. Warren's bond. So clearly I'm prepared to address some of the issues. I can address the specifics of the allegations. If you'd like to go through them one by one, I'm prepared to.
Go through them one by one.
That's
I have
fine.
some concerns
I understand.
as well.
If it's okay with the court, I have, having reviewed the pretrial services report, I did discuss the allegations with Mr. Warren, and recognizing his right to remain silent, it's my intention to address them on his behalf.
All right. Mr. Warren, first of all, the first report that was received was on October 30th. Mr. Warren's, one of his conditions of bond was that he was to have a GPS tether applied.
Yes.
Which was applied. He has a personal bond with that GPS tether. He was ordered to, the conditions, one of the conditions of the bond order was that he was to only go to from court, attorney appointments, medical, work, or church.
Yes, ma'am.
And it's my understanding that on October 29th, he was scheduled for a doctor's appointment. After the appointment, the defendant stopped for fast food on Telegraph Road. The tether company contacted the defendant regarding the stop. He said he stopped for fast food because he thought no one would notice.
I don't know that that's necessarily accurate, but I'm happy to explain he certainly did stop for fast food. The court has placed more significant limitations on Mr. Warren than just that. He is prohibited from driving a car and was obligated to forfeit his driver's license, which he did. His wife, who is present in court, took him to a doctor's appointment, He went to the doctor's appointment. He had not eaten anything the entire day. He happened to have shared that with his wife, and what they did was, on the way home after the doctor's appointment, they attempted to get Mr. Warren some food in the most expeditious way possible, which was to go drive-through, pick up 2 sandwiches, and then to get back on the road and drive home. So to the extent that he's prohibited from even attempting to provide sustenance for himself, then I guess he has to concede in that regard that he violated the condition of his bond. Again, this is all new to Mr. Warren. I have discussed it with him, and the only way that he's going to be able to alleviate or relieve himself from some of those conditions is if I make a request of you and you grant it. Otherwise, he's going to have to comply strictly, and you have my representation that he will.
He was ordered to comply strictly at his arraignment.
I understand.
And it was made very clear to him what he was allowed to and not to do.
Do you understand that for...
He has to make those arrangements ahead of time.
I appreciate that, Judge.
I don't want to start hearing excuses.
I'm not giving you
I
excuses.
thought I could go and, well, we're going to hear the next.
Well, I don't want to give you excuses, but I want, but
Any
please...
response from the people?
Well, Your Honor, I think it's pretty self-evident. He violated his bond condition.
So
if he was hungry and knew he wasn't eating, he could have brought food with him. He didn't have to stop in violation of his bond.
I think just to look at this from 20,000 feet, as opposed to looking at it being in the weeds with these sorts of things, when you actually think about someone whose life has been significantly altered, there are substantial limitations and restrictions. It's not used to them. He is doing his very best to comply. He understands now that any deviation whatsoever, even to provide for sustenance, even if he has to urinate, I guess the rule is he'll have to pee in a cup in the car.
Home.
I understand, but if he has...
He can go do that at the doctor's office. You're right. There's an alternative to this. We'll discuss that in a few minutes.
But we don't
But
see...
he's not the first person to
I
have
understand.
been put on the GPS tether and been in home confinement.
I understand.
And trust me, I have a transcript. I made it very, very clear to Mr. Warren about what he was allowed and not allowed to do.
I understand.
It's appearing to this court that he's making the decisions about what he's allowed and not allowed to do. So we'll go on to count 2.
Okay.
I received this on November 3rd of 2015. The defendant was required to be under pretrial services. He was to test randomly for alcohol and controlled substances as directed by his case manager. He was to have an alcohol PBT test on October 30th of 2015. He failed to show.
Yes.
What happened?
October 30th, I believe, was a Friday. Mr. Warren had, and he will actually concede more error than that, he had been calling the wrong phone number for 3 consecutive days, and the Friday that was October 30th, he had called the wrong phone number. When he realized the error of his ways and he recognized that he was calling the wrong number, he went in that Monday and actually, I believe, took not just a PBT, but I believe provided a urine sample, which I assume is an ETG test, as the court knows. ETG, which is ethyl glucuronide, allows the court to actually look further back.
Received a violation notice on November 3rd of 2015 indicating another violation of his traveling requirements as a condition of bond. Again, I've already indicated what the defendant is allowed to do. He's indicated he does real estate part-time. This involves that the defendant go to various locations throughout the day. The defendant also indicates he works as an antique shop 2 days per month and also paints, builds things part-time as well. The court had no knowledge of this. The only knowledge I had of his employment was that he was a real estate agent. That's what he indicated to the court when he was arraigned. However, as part of that, then there were arrangements made that it was agreed that he would email each morning his intended schedule so that it could be forwarded to the tether company. He's only provided 1 email to his case manager. That was on October 30th of 2015. He's also required to provide receipt verifications of stops at locations such as Home Depot or Lowe's if he needs to go to get work supplies. As of this date, the pretrial services case manager has only received one receipt from Home Depot dated October 27th. On November on that day, but did not include why he stopped at Myers. The case manager has also not received receipt verification as of the requested email as well.
Mr. Warren, in his antiquing, actually operates a used bookshop. The books that he finds books. He does one of three things with the books that he finds. He either recycles them and sells them or attempts to sell them in his antique booth. If they are in bad condition, he'll discard them. Other times, he will actually donate the books to charities. In order to box the books, he has historically gone to various markets and picked up used boxes. He went to Meijer that day to pick up boxes that had been discarded by Meijer in which to put books to either take to the antique shop or stop and where you go. It's very difficult.
This whole case is very difficult.
I appreciate that.
I thought I was making a very fair bond in allowing him to be out and allow him to continue his employment. It's getting very clear to me that Mr. Warren's decision is I'm going to do what I want to do and I'll explain it later.
I don't believe that's the case at all. And I've spent much more time with Mr. Warren than Your Honor has, with all due respect. There is absolutely no indication that Mr. Warren has that mindset, to be very frank with you. And I don't mean to put my foot down, but I have to on that point, Your Honor. Mr. Warren is aggrieved and is currently dealing with the aftermath of this horrible tragedy. There are no winners in this case, as I'm sure the court already knows. And Mr. Warren, with the assistance of his wife, his family, his children, his grandchildren, his therapist, and I are all trying to do the very best we can to assist him in complying with your conditions and allow him to live what life he has left under these conditions. And we're doing that as best we can.
What's the difficulty of sending an email to his case manager?
Mr. Warren he's never sent email. And we have documentation of the number of times. This is the first email that he ever sent in his entire life, was the email that he attempted to send to Lonnie, his pretrial services officer. And that email bounced back several times. So he senses, if we have to, we'll solicit the assistance of his wife, or we'll solicit the assistance of one of his children, or if need be, I and my staff will have to send out his morning emails to pretrial services.
All right. Are there any other employment, is there any other employment that Mr. Warren participates in other than what's been stated on the record?
There is nothing else that I'm aware of
today. Not going to find out any other types of employment?
No.
All right. Any response from the people?
Your Honor, I just think looking at the totality of the circumstances, the court has put it fairly accurately. While they may not seem to be egregious violations, they are, as a totality, a number of them starting to add up. And if either he's willfully doing it as he wants, or if he's unable to follow the court's directions, the court, should revoke his bond. I mean, whether it's intentional or just he's unable to follow those directions, something has to be done here. I mean, if he wants to remain on bond from the court's bond, he either needs to confirm and make sure he can follow those directions, whether it's willful or not. Otherwise, we are going to ask that this bond be revoked.
I've given the court the best representation I can that Mr. Warren will be able to comply with the court's bond. If it's the state's position that his bond should be revoked over what are unintentional or at best negligent oversights, then that would be par for the course for this case, unfortunately.
Saying that he didn't and I will allow a 10% provision. All other conditions of the previous bond will remain in full force and effect.
You'll note my
So I
objection.
want Mr. Warren to understand clearly now, there's $100,000 that is going to, or $10,000 that will be posted for you, but there's $100,000 on the line. So next time you decide that, gee, I'm hungry, I'm going to stop at McDonald's and hope no one notices, we're going to notice.
Judge.
And that's going to be $100,000.
So I just want to, first of all, I object to the increase in bond.
Okay?
There's a lack of notice prior to the hearing and for us to actually be able to address the issue. Second, I would ask if the court is going to continue over my objection to increase his bond to $100,000, cash surety 10%, then allow us to post the bond by Monday, 4 p.m.
I'm amending the bond at this time. My concern is the continual violations.
Then until the 10% is paid, could you just put him on flat house arrest then, and then...
He's not following my orders.
Well, if he's on house arrest, then he won't even be out.
He's not on house arrest, but he's making the decisions on what he wants to do.
I don't agree with that characterization.
Well, I'm sorry, but that's what, I believe that's what's happening. I have some real concerns. Those were my concerns. That's why I allowed a personal bond with those conditions. Just follow the conditions. He didn't do that. So the bond, I'm not revoking his bond, but I am amending it. I want to make sure that there's enough on the line so he understands we're not kidding around. So if he can't post, he's going to have to go with the deputies.
I'm sure we'll be able to post, but I need time to consult with he and his
fine.
wife. Can we sit in the conference room in the hallway and attempt to make some phone calls?
You have to go with the deputies. No, you can talk with them in the back.
Can I have a second, please? Hold on. I don't know what that means. Can you post them? Did your wife have 1,000? She's got it.
All rise. Court's now in recess.
So we have to have someone come and provide the other 2,000. Who's going to do that?
I don't know what her answer is. I don't know what she's got. She's got money. I just don't know where she's at.
Well, I'll ask her right now. Okay. Could you see here for a minute before you...
Well, we can take care of it back or in the office.
He's in my custody right now, so I'm going to take custody. Go ahead and put your hands behind your back.
I know, but it's such a show. So.
And you know what? We're going to go ahead and talk from the office and not in the court because they got other things to do. So go ahead on the other hand. This way.
What's that? You going to the car?
Yes, we'll need to check the 10,000.